Good afternoon, and thank you everyone for coming to this webinar. This is the Judicial Commission on Mental Health's Understanding Civil Commitments to State-Supported Living Centers from a legal and clinical perspective. And we're happy that all of you have joined us for this important session, which is focused on both of those legal and clinical considerations. Today's webinar will feature two experts offering complementary perspectives. We have Beth Mitchell, who's a senior attorney with Disability Rights Texas, who will provide an overview of the legal framework governing civil commitments to SSLCs. She'll cover statutory requirements under Chapter 593 of the Texas Health and Safety Code, due process protections for individuals, and key judicial findings necessary for a lawful commitment. And then we have Erin Lawler, who I want to mention is saving us with this presentation. She stepped in about 2 days ago after we had a speaker cancel. So on such short notice, she jumped into action and is really helping us out by bringing us her expertise today. So thank you, Erin. Erin is the Chief of System Policy at the Texas Council of Community Centers, and she will begin by walking us through the role of the local intellectual and developmental disability authorities, LIDAs. She'll explain how interdisciplinary team evaluations are conducted, how placement recommendations are developed, and what recent legislative changes mean for practice in the field. So by the end of this session, we hope that you'll walk away with a deeper understanding of how legal and clinical professionals collaborate to support individuals with IDD in the least restrictive and most appropriate setting. So thank you for being here. Thank you to our speakers, and we'll go ahead and get started. Erin, I'll bring up your PowerPoint and share my screen. You can just let me know when to change the slides.
Great. Thank you very much, Rose. Good afternoon to all of the participants, and thank you so much for being here and caring enough about this topic to log on. As Rose said, I'm the Chief of System Policy with the Texas Council of Community Centers. The Texas Council is the association that represents all 39 local mental health authorities throughout the state and the 39 local IDD authorities throughout the state. I've been with Texas Council for about 10 years. And services for people with intellectual and developmental disabilities, or IDD, which is our topic for today, are very close to my heart. I'm a sibling. I have a sister with IDD who lives in Texas, so I'm very invested in the future of our service delivery system and making sure it's there to support her and all of her peers. So today our topic is, I called it demystifying civil commitments to state-supported living centers, because this is an area that not a lot of people know about and that can be potentially intimidating or confusing when you first encounter it. Next slide, please. So I'll start with just the basics, which is, what is an intellectual disability? What is a developmental disability? And what is this kind of conglomeration of conditions that we call IDD? So important to know about intellectual disabilities is that it's a condition that's characterized by limitations in reasoning, learning, problem solving, practical social skills. It was formerly described by the term mental retardation. That is a term that is now considered disrespectful. So I won't be using it. I'll be using the term intellectual disability, but I think it's important just to say that at the beginning, because people are familiar with the term mental retardation, and it conjures to mind, maybe someone who has Down syndrome or something of that nature. Intellectual disability is harder to grasp, and sometimes people confuse it with other learning disabilities or cognitive impairments. Are we talking about dyslexia or something of that nature? So it's important to understand that intellectual disability is really something more significant, that has a significant impact on a person's life. It's characterized by a low IQ, and it must have been present in the developmental period for the person, which means that it manifested before the age of 18. And most ID, intellectual disability, is present at birth, like for a person with Down syndrome, a person who has any condition that's going to impact IQ, that it's very common for that to be genetic and have been present since birth. And then relatedly, we also have the category of developmental disability. And together we talk about those as intellectual and developmental disabilities, or IDD. Developmental disability is you can picture a Venn diagram and think you have ID on one hand and DD on the other, and a lot of people who are going to fall into both. But a developmental disability is a severe chronic condition that results in limitations and onset before age of 22. So that would be like a person with cerebral palsy, for example. They may have an intellectual disability in addition to the developmental disability, but not necessarily. There's people with autism, which would be considered a developmental disability, who have high IQ and would not be considered a person with ID. So just important for our purposes here today to understand that intellectual disability, which is our focus, is a pretty narrow and distinct population. It does not refer to people who have a mental health condition, a traumatic brain injury that occurred outside of the developmental developmental period, dementia, Alzheimer's. Those are going to fall into a different category. Next slide, please. So I think my next slide is, what is a local IDD authority? Again, those are the institutions that I represent, and why I'm here today is because they have an integral function in providing services or access to services for people with intellectual disabilities. They are the entry point to all of the publicly funded services for people with intellectual disabilities in Texas. Those tend to be Medicaid funded services, but not exclusively. The local IDD authority, your local IDD authority, every county has one, is a unit of local government. It's led by a board of elected officials. It is statutorily authorized to perform certain functions on behalf of the state. So the state of Texas and the state's Medicaid authority, which is the Health and Human Services Commission, have certain responsibilities, and some of those responsibilities can be delegated out to other entities. Not every state does it this way. So certain access and intake functions that are performed by the local IDD authority, if you were in another state, you might find that it's done by a regional office of that state Medicaid entity. It could be conducted by like HHSC's regional office, the equivalent of such. But instead, they have chosen to delegate certain functions to community organizations known as the local IDD authorities that are really ingrained in the local community, familiar with local resources, part of local dynamics and relationships, including with the courts. So I mentioned that the local IDD authorities are contracted with the Texas Health and Human Services Commission. A performance contract with HHSC governs a lot of our functions and how we relate to other entities. And every one of the 254 counties of Texas has a designated local IDD authority. Now, we don't have 254 local IDD authorities, we have 39. So you can tell many cover large regions. Next slide, please. So I'm going to ease us into this topic by just talking very generally about how do people with intellectual disabilities interact with the court system? Why is this an important topic for the Judicial Commission on Mental Health to be bringing to you today? The easy answer is that most people with intellectual disabilities interact with the court the same way any other resident of Texas would. However, due to the distinct nature of the disability type, individuals with intellectual disabilities are more likely to be victims of crime, including abuse and neglect. And they do have certain distinct intercept points, which can include that when a person with intellectual disabilities lacks appropriate supports, they are vulnerable to falling through the cracks and ending up in an encounter or interaction with law enforcement around homelessness, for example. If they are in a behavioral health crisis, often 911 is called, so there's an interaction there. And we've seen a recent very unfortunate trend where people with ID are more susceptible to trafficking, to human trafficking. So that's of significant concern. You are probably familiar with interactions that stem from Department of Family and Protective Services, conservatorship type issues. It can happen that family circumstances require an out-of-home placement for a child or a teen with disabilities. Finally, a parent or another interested party, in a person's circle of support may come forward to the court seeking guardianship for an adult, or an alternative to guardianship, like medical power of attorney, supported decision-making, something of that nature. And finally, our topic today is the intercept with the court system around civil commitments, which is placement in a residential setting that requires a court order. Next slide, please. I wanted to highlight for you that the state of Texas has actually adopted a philosophy around services and supports for people with intellectual disabilities. And this has been in the Texas Administrative Code for decades. And it speaks to a continuum of care that would range all the way from providing supports that allow a person to remain at home with family, surrounded by natural supports, to the most intensive setting on the continuum, which is the state-supported living centers, and that's our topic today. And that the state-supported living centers are meant to function not in isolation, but as part of a continuum of care. And because they are a limited resource, the Texas Administrative Code actually lays out the sort of characteristics of the type of person who is appropriate for services in an SSLC. And the words they use around that have to do with severe or profound intellectual disability and people with intellectual disabilities who also are medically fragile or who have high behavioral needs. Next slide, please. So what are the state-supported living centers? There are 13 of them throughout the state, and they provide comprehensive campus-based care to people with intellectual disabilities. And that is specifically to people with ID. Like I said, not for people who may experience brain injury or something of that nature. The standard is pretty high, and we're going to hear from Beth about how the standard is applied. They're also a limited resource. We're a big state, and there are about 2,500 people who are supported in one of the SSLCs statewide. So that's not a very big number. And the census has been, slowly declining over time. So back to why do we have this intercept with the courts? Well, many people with intellectual disability do not have full legal capacity and cannot voluntarily consent to admission to an SSLC. So for that reason, Texas state law lays out an involuntary commitment process and establishes jurisdiction in the county courts. So due to the resource limitations around the SSLCs, capacity is very limited, as I mentioned, and the application process, even with a court order in place, can take several months. And I think that's important for people to know who maybe aren't familiar with the system and are hoping for an emergency type placement. It's important to know that these placements don't happen overnight, and not just is it not overnight, it's typically a several month process. Next slide, please. So another piece of the demystifying that I just wanted to touch on briefly, and we don't need to do a whole masterclass on this, but a person with IDD may fall into a number of different sort of legal characterizations. And it's easy to conflate them or to think because a person meets one standard, they must automatically meet the others. So for example, someone might say, well, the person has a guardian, so they've already been found incapacitated by a court. Doesn't that automatically mean that they qualify for an SSLC? And the answer is no. So I've just laid out here, a single person with IDD may fall into one or more of these categories, but the categories are independent from one another. So for example, they may be found incompetent to stand trial, and that has to do with their ability to consult with their own attorney and understand the process. They may be eligible for community-based services that would support them to live at home or independently or in a small group home with other people with intellectual disabilities. But whether they're eligible for that or not is going to be program specific and will relate to their income eligibility and also functional criteria about their own circumstances and what level of independence they're able to have. They may be appropriate for guardianship, and that has everything to do with whether they would be found incapacitated based on standards in the estates code. And finally, they may be eligible for admission to a state-supported living center, or SSLC, our topic today. And that relates to 4 factors laid out in law, including whether they pose a risk of harm to self or others, or are unable to meet their own basic needs. And Beth will be going into detail on how those are determined. Next slide, please. Just to illustrate for y'all exactly how limited this resource is, I wanted to just share some up-to-date data on admissions to the state-supported living centers. And again, with demystifying, I wanted to take apart a little bit what you can see in statute, which is Texas Health and Safety Code, chapter 593. It's where you're going to find the most and best guidance around SSLC admission standards. And if you look at that code on its own, you would come away with the impression that people are able to access SSLCs through a number of doors, basically, that they could have an emergency admission, a regular voluntary admission, a respite admission, or a number of involuntary options. So I'm briefly going to talk about the voluntary categories. I think people get excited when they see that there's such a thing as an emergency admission to the SSLC, because that sounds like something that could be very helpful to a person in crisis, probably people that you have, encountered in your practice. But it's important to be aware that emergency doesn't mean expedited, it means time limited. So rather than a long-term commitment where the SSLC becomes the person's home, potentially for years, potentially lifelong, emergency refers to a person who needs the kind of services the SSLC provides, comprehensive, wraparound, residential, campus-based, but for less than 12 months, with the goal of the person becoming more stabilized, addressing whatever medical or behavioral issue they have, and then returning to the community. That's what an emergency admission refers to. And you can see, in 2013, there were 6. In 2023, there were 4. This is a very limited application. And then a regular admission would refer to a person, an adult, who is able to consent to their own admission. So you can see the state of Texas has not accepted or processed a regular admission in over 10 years. And that's because it would be a very rare person who would fall into this category of both having needs extensive enough that they meet eligibility criteria and also retaining their own legal capacity and ability to consent. That would be quite an unusual person who would meet all of those criteria simultaneously. And that poses challenges for just the operations of an SSLC. If a person is there not under any kind of commitment order, they have, the same rights as you and I do. They could leave the SSLC tomorrow. They could refuse to consent to medications that they don't want to take, and so on. So that causes some challenges just for how the SSLC is run. And so for that reason, it's preferred that a person has a court order. Finally, respite admissions, which are also voluntary, refers to a really time-limited stay, like under 30 days. And the SSLCs simply don't have vacancies available for those. They did at one time, they don't anymore. So there haven't been any respite admissions in over 10 years. So our focus today is on involuntary, because you can see really how limited anything that falls into the category of voluntary is. So Beth and I will be talking today about regular involuntary admissions. That means an admission that comes from the community. A family member who steps forward, like an elderly parent, is seeking a long-term service for their child, their adult child, would be an example of a regular involuntary admission. They petition the court. They apply to the court directly. And then the other is going to refer to your forensic admissions, people who have been found incompetent to stand trial and things of that nature, or who are there for an evaluation of competency. And I understand those will be discussed in a webinar next month. So next slide, please. This is just to give you a sense of where people come from. Where were they immediately prior to admission to an SSLC? And so you'll see the biggest category, the plurality of people come from correctional facilities, which probably doesn't come as a surprise to any of you listening. What is a little bit surprising, perhaps, and tells us kind of a sad story, is that the second biggest category is people who already have a service in the community, our most comprehensive community-based service, which is known as Home and Community-Based Services, HCS. You may have heard people talk about the HCS waiver. That is a Medicaid-funded service that is, as I said, the most really comprehensive Medicaid waiver that we have, and it includes residential options. So a person could be supported in the HCS waiver and finding it's not intensive enough to meet their needs, and that would prompt a transition to an SSLC. So when I say disappointing, it's just, we would hope that HCS would be funded and designed in such a way that it really could meet everyone's needs, including the needs of people with high medical needs or high behavior needs, so that everyone has the option to live in the community, in a smaller setting. So that's just something that's a public policy kind of consideration that people in my line of work look at very closely, and I'm sure Beth does as well, what it takes to support a person successfully in the community so that an institutional setting like an SSLC is a choice, not the only place that they can be successfully supported. Next slide, please. So how does a person access the SSLC if they aren't already on some kind of path because they are going to end up as a forensic admission, but just a person living their life in the community, either at home with family or maybe in an HCS, group home or something of that nature. When it becomes obvious that the person's needs are maybe greater than the supports around them can accommodate, how would they go about accessing the SSLC? You don't just go knock on the door and say, do you have a vacancy? It's a complicated process. So this is to answer that question. So as of September 2023, so relatively new, a parent of a minor or a legal guardian of an adult may apply to the court directly. So they would approach the county court where the individual has residence, the county where the individual has residence, and apply to the county clerk. And the court is then responsible to make an eligibility determination. And what's new about this is that that can now occur without direct involvement from your local IDD authority. And if the court believes that on the strength of the application that the parent or guardian filed, there's enough information there for them to make a determination that the person meets eligibility with the criteria you're going to hear about from Beth, then the court can order that without involvement of the local IDD authority. And at that point, they issue the order. The order is communicated to the individual, to their family members, and to the local IDD authority, which then picks it up at that point and makes the application to the SSLC itself. That's the new route as of 2023. The more traditional route that existed before and that you may be more familiar with is that any interested person in a person's life, which could be family member, friend, it could be a service provider, it could be the local IDD authority, it could be HHSC, can seek a recommendation from the local IDD authority, those community organizations that I represent, for an SSLC admission for the person. And at that point, the local IDD authority is responsible to convene a meeting of a team of experts, which will include the person and the person's family, but also professionals who work in this space, to consider the person and the person's needs and whether they meet eligibility criteria. And they make a formal recommendation to the court. And that you may have referred to as an interdisciplinary team meeting, or an IDT. The IDT report is submitted to the court, and the court makes the final determination based on the information presented in the report, whether the person meets eligibility criteria. And again, at that point, the application and kind of like getting the football across the finish line is the responsibility of the local IDD authority. Next slide, please.
Oh, we had
And
one quick question in the
oh, sure.
chat.
Yeah.
The question is, does this mean a parent or guardian can directly apply even if the person has never had an IDD? They're referring to the new referral process since September 2023, where they apply without the LITA.
Mhm. So I might need a little clarification on what the question is asking, but I'm going to do my best because I heard you say without an IDD. So I'm not sure if that means without a
Oh, no,
determination that
It
sorry,
actually,
without.
sorry, Erin, it says DID.
without a DID.
My
Okay.
apologies.
So the person will need to be able to demonstrate intellectual disability. The eligibility criteria were not changed by establishment of the new process. So, and you'll hear more about this from Beth. There's 4 prongs that all need to be satisfied for a person to meet eligibility. And the very first one is that they have intellectual disability. So that will need to be demonstrated, to the court satisfaction. And typically the way that's done is a determination of intellectual disability or DID, which is like a diagnostic tool. You'll hear more about it from Beth, can only be conducted by certain professionals. But either way, they will need a DID before the admission can be completed, because that's part of the required application to the SSLC. So whether the court looks for a DID or not, and I think that they would, you would need it for the final application, the big packet of papers that's going to go to the SSLC, which I think is what I talk about on my next slide. Yeah, this is just, I'm not going to read this. It's just to give you a sense of why things take so long. So the court process itself can take a few months, between getting on the court's docket, compiling everything, making the hearing happen, and the court's deliberation. I think there are timelines in statute technically, but I think often it ends up taking a few months. And then even with a court order in hand, the application to the facility, to the SSLC, is quite comprehensive. You can see there's 19 things laid out in the Texas Administrative Code that need to be compiled and submitted. And some of what's here is not just pulling a piece of paper from a file cabinet. It's about conducting an evaluation, conducting an assessment, holding a meeting, compiling information that then gets submitted. So, it's quite a rigorous process. And I just wanted to illustrate this. You can see what a gauntlet it is to get through. And that there's a reason it takes so long. It's time consuming. And at that point, the application goes to the facility, and the facility then reviews it, holds its own meeting, and determines whether they have a vacancy, and a vacancy that's appropriate for that particular person, based on the person's gender, age, and other needs. Christy, did you have a question?
Yeah, in the chat, someone asked, and I know this isn't the focus of today, so we might want to just do a broad overview, but when might it be beneficial for an individual or family to bypass the LITA in this process?
Mhm.
Maybe we should wait for some of these questions till the end, because once we talk about some of the other criteria, that may actually answer some of those questions.
Sure. We'll
Sure.
Put that one on hold. We'll come back.
Yeah, I'm fine with that. And I think this is my last substantive slide before I hand it off to Beth. There is a persistent myth that I just wanted to address when I take advantage of being in front of y'all, because this is a myth that I wish would die. So the myth is that a person must have tried and failed in a community setting before they can be determined eligible for an SSLC. So, and you will hear this, I've heard it many times. Well, we can't do an SSLC application yet because the person hasn't tried 3 group homes. I hear that often. Or they need to have tried HCS, and they also need to try another model we're not getting into today, community-based ICF. I know why that myth exists, but it is a myth. The fact is that the Texas Administrative Code sets a standard that is individualized. It is person-centered. So there is no universal rule about tried and failed. It's more about evaluating the person, their individual needs, what is available to them in the community, and what is appropriate to meet their needs. And that can be done through, a team meeting. That's not to say this isn't a rigorous standard. It is. People should have knowledge of what's available to them in the community, and it should be looked at closely whether their needs can be met. SSLC admissions should be taken seriously because they're a limited resource, and also because often that ends up being a lifelong decision. So I'm sure Beth will talk about this from, a little bit of a civil liberties standpoint. But for all those reasons, SSLC admissions should be, subject to a pretty high standard. But the standard does not require that the person has encountered some kind of harm first. And that's the part that I think needs to be gotten away from. The person doesn't need to have lived in a group home and had something bad happen to them or someone else before saying we can consider an SSLC. So with that, I think my final slide just has my contact information. Oh no, one more. Areas for future collaboration and improvement. Again, taking advantage of being in front of this illustrious group. I do see room for improvement in terms of how the entities involved in an SSLC application work together. We all know that people and families do best when they have good, comprehensive information, and they get that information early and often, at every intercept point, starting with the pediatrician, the school, and so on. So I think local entities could work together to ensure that good information is available. I don't expect that a county clerk would be able to explain about waivers and things of that nature. So, more cooperation, collaboration, information sharing between courts and local IDD authorities, I think would be a positive. And because the process that I talked about a little bit, and Beth will go into in more detail, the new process as of 2023, where a parent or a guardian can approach the court directly, because that's new, I think more information about it would be helpful to every party involved, a better understanding of what that process is. So families aren't just sort of floating and figuring out how to apply to a court without guidance. So as an example, Texas Council and other IDD stakeholders conducted a training recently at the Texas Association of Counties Probate Academy. And I talked to a group of county attorneys and county judges about all of this. And it was sort of like, a little deer in the headlights, if I can say that. So I think just continued engagement and training and sharing of information, from one world to another, not expecting the courts to be experts in social services, but helping them know where to go to get the expert information would be a positive thing. And so here's my contact information. Feel free to email me. I included my phone, but it only works for text because I'm a millennial. If you call me on my phone, I will throw it in the trash. So just text me first, please. All right, and with that, I'll turn it over to Beth.
Good afternoon. So I work for Disability Rights Texas, so our perspective is more based on client rights. But we do understand the need to balance those rights with families and the court's needs for information. And so my presentation is going to go more into the facts of what are required for the actual commitment to an SSLC. So we can go on to the first slide or the next slide. So I wanted to talk about some of the key definitions that are required when it's related to an actual commitment. When we're talking about the involuntary commitment, not the emergency, not the voluntary, not some of the others, but when we're talking about involuntary, one is the intellectual disability piece that Erin talked about, which does require a DID, and we'll go into that a little bit later. But in order to be at an SSLC, you do have to have an intellectual disability. You can't have a developmental disability. It has to only be an intellectual disability. The other is the commitment that is the criteria that allows for the commitment is a commitment to a residential care facility. The definition of a residential care facility is only an SSLC. So it's not as if the residential care facility could be a large ICF or could be any other type of placement. It has to be an SSLC. And then as Erin had spoken about in terms of least restrictive alternative, it's just least confining, least intrusive, that's appropriate to the individual. Doesn't mean there had to have been attempts at many other or, community placements, but there has to be an understanding that the person has tried or there has been a review of least restrictive alternatives and they are not appropriate. So I think those are key definitions to remember when you're looking at applying or for a commitment to a residential care facility. Okay, next slide. So as Erin spoke, residential commitment hearings, civil commitment hearings don't occur that frequently. And oftentimes they're confused with mental health proceedings because mental health proceedings happen all the time. Part of the difference is that mental health commitment hearings there's several of them, right? So there are emergency detentions that have to occur, and there's a hearing after that. There's a hearing for a probable cause. So you get a mental health hearing for that. And then you have hearings for yearly hearings afterwards. And so there's always hearings for mental health proceedings. Under IDD, I'm going to say IDD commitment proceedings, they're very infrequent. And once a person is committed under a IDD commitment to an SSLC, it's just a long-term commitment. There is no actual end date. Now we'll talk about what that actually means, but that's why you don't see a lot of other hearings like you do in the mental health side, where the mental health side, it is a explicit time-limited commitment and the court must review that commitment when that time limit is up. Under the SSLC commitments, it's long-term, so there is no time limit. Now, there's an internal time limit at the SSLCs, and we'll talk about that a little bit as we go through it a little bit later. But I think, again, there's the confusion with that. The other difference is that the burden of proof is different, right? For mental health commitments, it's clear and convincing evidence. That's what's needed to prove that the person needs to be in a mental health facility. In order to commit somebody to the SSLC, you have to find that they need the commitment beyond a reasonable doubt. And again, there's that reason about the person's going to be there long term. So you better know for sure that they need to be committed because it's just a long-term commitment. There's no additional kind of set hearings that might bring up the issue later on. So those are some of the main differences. Next slide. So in order to have a hearing, there has to be due process protections, any kind of commitment to end, just like in jail, you have due process protections. In a state hospital, you have due process protections. Anytime that you will be confined, you are required to have due process protections based on Supreme Court case law. And that means that the individual, not the family, the individual has a right to counsel. That counsel is the individual's counsel, not the parents' counsel, not family's counsel, not friends' counsel. They have a duty to the client. They have a duty, even if the client does not have capacity to tell them exactly what they want, they have a duty to ensure that their rights are advocated for to the best of their ability. They also have a right to notice. They have a right to be present at the hearing. There's actually a right to a jury trial as well. And as we talked about before, the standard is beyond a reasonable doubt. And that rules of evidence apply. So when you have the commitment hearing, all the same rules that would apply to any other hearing in terms of objections, in terms of not having witnesses present while other witnesses are testifying, all of those same evidentiary rules apply in a commitment proceeding. Next slide. So we talked about, Erin talked about the statutory requirements, and there are several, and each one of these have to be found beyond a reasonable doubt. So it can't be just that one is found beyond a reasonable doubt. Every single one of these has to be found beyond a reasonable doubt. So you have to find that the person has an intellectual disability. And Erin talked a little bit about what intellectual disability means, and a DID, we'll get to that in a second. But the other is that it's because of that intellectual disability, so that the person poses a substantial risk of harm or cannot meet their basic needs. So so it's either one of those have to be proven beyond a reasonable doubt, that there are not any least restrictive alternatives out there that are available and that would satisfy the needs of the individual, and that the SSLC can meet their needs. So all of those have to be proven beyond a reasonable doubt. And again, it has to be because of their IDD. So it can't be, well, they have an intellectual disability, but it is their seizure activity that is causing them to not be able to meet their basic needs, right? It has to be that it's their intellectual disability that is causing them to be that substantial risk that the SSLC can meet their needs. So that's a very important requirement. And you see that on the mental health side too, right? Like it also says that in order to commit somebody to a state hospital, the person has a mental illness, but not only that they have the mental illness, it is that the mental illness is causing them to be dangerous to themselves or others. So oftentimes, somebody might have an intellectual disability and be dangerous, and then there might be an attempt to commit them to a state hospital because of that dangerousness. But again, that's the wrong commitment, because the dangerousness is not because of the mental illness. It may be because of the intellectual disability, which means the commitment or the attempt of commitment should be to the SSLC. So that distinction is really important. Next slide. So when we talked about the person having an intellectual disability, there does have to be a determination of intellectual disability. That determination can be done only by an authorized provider. And there's a list of who those authorized providers are. A physician licensed to practice in the state, a psychologist licensed to practice in the state, a professional licensed to practice in the state and certified by the department, or a provider who might not be a professional but was certified before September of 2013. And so any of those individuals can and is an authorized provider and can do a determination of an intellectual disability. Once that determination is made, the individual has a right to challenge that determination, be it that they were found to have an intellectual disability or they were found not to have an intellectual disability. They have a right to challenge that, and they can go to an administrative hearing. And then they can also, after the administrative hearing, if they don't like the results of the administrative hearing, they can actually appeal it to contest those findings. So there are several processes along the way. As Erin said, potentially getting to an SSLC commitment could be very long, because you first have to get through this process, and this process may be the hearings that the person is challenging and contesting, and until those are over, there's not been an actual determination of intellectual disability. So there are all these provisions that are in place first that require it. And so I also wanted, make a, we're talking about these statutes in 593. These statutes, besides what happened in 2023, haven't been changed very much at all. They were initiated in 1991, and then there were some changes in 2015. But and they were minor, but other than that, there really haven't been any changes to this code. Whereas on the mental health code, you'll see changes almost yearly, right? But under this code, there are very, very few changes that you ever see. It's kind of been, but most people have not really thought of or used these provisions for commitment that frequently, as Erin said. So there hasn't been a lot of attention to these sections of the code. Next slide. So when we talked about the different requirements for commitment, one was they had to have an intellectual disability. The other was they had to have a substantial risk. The administrative code defines a substantial risk as Erin had talked about, severe and profound, right? So the IQ is 4+ standard deviations below the mean, which would make them severe or profound intellectual disability. So you have to have that, or you can have an ICAP level of 1 to 4. So it's basically your needs level. of a 1 to 4, which is done by a professional in determining what those are. Or you can have a ICAP level of 5 or 6. Again, this is a needs assessment, which would mean you need 100, along with 180 plus minutes per week of nursing needs or dangerous behaviors needing intensive staff support. So that's the definition from the TAC as to what substantial risk is. Now, again, this is the TAC, this is HHSC's interpretation of what they define as substantial risk from the health and safety code, from the statute itself. So I don't know that you necessarily see often that courts actually look, when they're doing commitment proceedings, that they look directly to this provision in making that determination of substantial risk, but there is that definition that is in the administrative code. Next slide. So as Erin said, in order to even think about getting somebody into an SSLC, you have to file an application for commitment, and that has to be filed with the court. And it can be filed by a parent, a guardian, a court, a LITA, or anybody. Anybody can file an application. The application includes a request for an IDT report and a recommendation that the person is in need of SSLC placement. And it's filed with the county clerk where the resident currently resides. As Erin spoke about in terms of the 2023 new law that may not require an IDT report, the application then would only require a recommendation that the person is in need of an SSLC. It would not need to be an application that's requesting an IDT report. So if you are a parent of a minor or a guardian, your application would just need to indicate that there's a recommendation that the person is in need of an SSLC. Everybody else would have to request the IDT report and say there's a recommendation that the person needs an SSLC placement. Next slide. The contents of the application is basically, name, address, birth date, like just general resident information, why there's a reason to support the commitment that the person believes the commitment is necessary, a statement of why less appropriate alternatives are not appropriate, and then a copy of the IDT report if it was required, which for parents of minors and guardians it wouldn't be required, and completed. So in the application, even if an IDT report is necessary, it may not be completed yet. You may just be requesting the application. So if it's not completed, you don't need to include it with that application, and you don't need to wait for it to be completed before you file the application. Okay, so you can file the application, and if there isn't an IDT report, the court will actually order the LITA to complete an IDT report. Next slide. So if an IDT report is required, right? So this is the court, the LITA, or some other interested party that's not a guardian or a parent of a minor. A person may not be committed unless there is an IDT report saying that the SSLC is appropriate. And that IDT report cannot be more than 6 months old. So if there was an IDT report a year ago, that would not be sufficient. The court would have to order a new IDT report. So if you are not a guardian or a parent of a minor and you do not have an IDT report within 6 months saying the person meets criteria for an SSLC, the court cannot commit the person to the SSLC. Next slide. So the composition of the IDT, which is important, there was a case where the composition did not include the individual and did not include many parties that should have been part of the IDT team. And the court said that that was not sufficient and they needed to redo the IDT report. And so those people, as I say here, is the individual. The individual has to be part of that team. The LAR or a parent or anybody else. The other is qualified professionals who have training and experience with ID, right? So that's another big area of individuals who have to be part of it. It can be other people that that either the individual or the LAR request to be present. It could include school reps and other service providers. Next slide. I'm running out of time, so I'm going to start going really quick. What the IDT must contain. So it's an interview with the person and the guardian. They have to review medical and social history, assessments, psychological evals, adaptive behavior levels. So it's not just, you know, based on generally we're going to make this decision. They are supposed to actually review documents, take time, and determine and obtain any other assessments they think they might not need, and then recommend whether or not the person needs an SSLC placement. And then when they finalize the report, everybody needs to sign it who is part of that team, and it actually then needs to be sent to the individual, to the court, and to the attorneys. Next slide. So without the IDT report, so if you are a parent of a minor or a guardian, you do not have to have an IDT report. All you have to do is petition or provide the application saying that you think that an SSLC placement is recommended, and submit that to the court. So although you don't need the IDT report, even and you submit that application, you still have to go to court. The person still gets the right to a hearing. And at the hearing, the court still has to look at all of those criteria and make sure that you have proven each of those criteria beyond a reasonable doubt. So those don't change, right? So that you still have to show to the court that the person had a DID, and that because they have an intellectual disability, that person is a substantial danger to themselves or others, and or that they can't meet their basic needs, and or that they there's no less restrictive alternatives and the SSLC is appropriate. So that still has to be proven at the court. And so usually that's proven through the IDT report. Now that there is no IDT report, it's going to be up to the parent or the guardian to figure out how to prove that up in a court of law. Next slide. Wait, can we go back? We're going to come back to this slide. Can we go to the next slide though? So, as I was saying, that a judicial finding without an IDT report, evidence is still required. The courts, you can rely on the guardian. The guardian can bring records that they have. They can bring clinical evaluations. They can bring people and provide testimony. But the court can't make this finding in a vacuum. They have to have evidence. They have to have evidence to support each of those findings beyond a reasonable doubt. And in that case that I had talked about before, next slide, in the JH case or JA case, no, not that one, the one, yeah. The court had said that although there's nothing in 593 that requires expert or psychiatric testimony, they did say that without having some kind of expert testimony, that any finding would be factually insufficient and it would risk injustice. So that court suggests that even though there doesn't need to be expert testimony, that without it, it would be very, very hard to prove beyond a reasonable doubt all of the findings that are required in the code. So although a parent can try to prove it on their own, it still may be helpful if a parent or a guardian is trying to do this, that they still do have some expert that they could call that would be able to clarify to the court that all of the findings were met beyond a reasonable doubt. And then go back up to that first slide that we skipped. Yeah. So if a court does actually commit somebody to an SSLC, when it's a parent or a guardian, because the LITA is not involved, that parent or guardian is required to notify the LITA. Otherwise, the LITA would not know, and the LITA would not be able to submit the application to the SSLC, right? So the parent submitted the application to the court for a commitment. Now, after their commitment has been found, there needs to be an application to the SSLC, as Erin was talked about, which is a whole nother process. But the parent needs to make that application to the LITA, so the LITA knows that the court has made that ruling, and now we needs to start that process. And in that application process, the parent or guardian has to assist in completing a lot of that paperwork that Erin left on her slides that were like, I don't know, what did you say, 17 or something long? So they have to assist in providing those. I think my final slide. So yeah, no set term limits. We talked about this before in terms of duration, right? There isn't a set time limit. But even though there's not a set time limit, the Supreme Court has repeatedly said that once a person no longer meets commitment criteria, they must be released. So even though there's no set time limit for the court to have to reevaluate whether or not the person meets criteria, if the SSLC determines that they do not meet criteria, they have to start release proceedings. And those release proceedings are through themselves. They'll do a discharge, they do a whole discharge planning. They don't have to go back to the court. They can just they can just make sure they have what they call a CLDP, right? A community living discharge plan, and discharge the individual back into the community. They do not have to tell the court anything. On the civil side, criminal side, completely different story. Civil side, they can just send them to the community. And there are actually provisions within 593 that if the individual or if the LAR thought the person needed to be released, no longer met commitment criteria, and the SSLC didn't think that were true, that they could actually request an administrative hearing to be released from the facility. So there's an internal process that HHSC has to ensure somebody is released if they no longer meet commitment criteria. And so, as I said, the release can happen when criteria is no longer met, which would hopefully be when the IDT also recommends that they no longer need to be there, or the person or guardian wants the community transition. And then again, this is not a declaration of incompetency. And so even though they are there involuntarily, if they don't have a guardian, or they're not a parent, they're not a minor, they still get to make decisions while they're in the SSLC. So if the team determines that they still have capacity to make decisions, they still get to make decisions about whether or not they want to take medications, whether or not they want certain habilitation services. So they get to make those decisions unless their IDT determines that we don't think they have capacity. And then then it turns over to the director, who can then make those decisions. Sorry for going really fast at the end, but I know we were running out of time. So if an individual is committed, they have a right to appeal. It's not an accelerated setting, so it's just the appeal is 30 days after the court's order. Civil procedure rules apply. And interestingly, the court actually can stay that commitment, can say no, the person can remain in the community pending that appeal, which is not common, and it's not the same over on the mental health side.
Thank you so much. That was a lot. We have several questions in the chat. So I don't know if you all could stay a few more minutes, answer some questions. We could also follow up with an email and try to answer questions. Can you see the chat, Beth? And Erin, I know you've probably had a chance to read them a little bit more while Beth
had
was
the advantage of looking at them while Beth was talking.
Do you want to jump in, Erin, for any that you've
Sure.
been able to read?
Yes, and I can stay on. I'm not in a rush. So one of the questions was, when would the Senate Bill 944 route be beneficial? So that's the route where the local IDD authority is not involved up front. A parent of a minor or a legal guardian of an adult applies to the court directly. The legislative intent around SB 944 was to create ready access. So it's possible that a parent or guardian with voluminous records, involved other parties, involved experts, could apply to the court directly, and maybe that would go a little bit faster than first seeking the recommendation through the LITA, giving the LITA time to convene the IDT, gather records, especially if there isn't an existing relationship with the LITA. It could also be, well, I would say that's probably the primary, when would it ever be advantageous? I represent the LITA, so, I'm biased, and I'm going to say I think it's a good idea to be involved with your LITA kind of no matter what, and that they can be very supportive in handling the administrative piece of interacting with the court and then submitting the application. Often the family member who is advocating on behalf of their loved one is caught up in the day-to-day of managing life, just, managing the circumstances of that individual's, life and the crisis that is unfolding, usually that prompts the wish to reside in an SSLC. So having the LITA there to hold your hand and be the compiler of documents and the person communicating with the court, I think can be, very beneficial.
I would agree as well. And I think, ultimately, once the person is committed to the SSLC, the IDT is going to be then involved anyway. And so, it's important, I would think, to really have them involved prior as well for that reason. The next is we've run into issues of release of records, and I'm not sure who is the we for that's relating to that. I can say that on the mental health side, there was an explicit provision that was put in place that allowed the ability to share information with people who were involved as long as it related to ensuring further care and treatment. And it was put there explicitly to allow this kind of sharing of information. It doesn't, I have to go back and look, and maybe Erin, but I'm not sure that it applies across the board to IDD as well. It was really meant mostly on the mental health side, and it kind of bypassed HIPAA requirements, although not necessarily bypassing, because there was issues about whether it did meet HIPAA or not. So I think as for now on the ID side, unless, like I said, unless Erin has looked at it and I'm recalling wrong about it, you would still need to have releases to third parties to get that information back and forth.
Yeah, I don't have much to add to that because in my work with the LITAs on these kind of cases, I haven't encountered that folks were not, were reticent to release records. But I would say you can work with, the county attorney who's taking on the case, or the defense attorney, whichever side you're on, whoever you're interacting with, they should be able to advise you on what's necessary to get those documents available to the court.
I just wanted to jump in and say we're going to wrap this up at about 1:05, so we'll have time for another question or two, but we will send out an email with a recording of this webinar. So if you have to jump off, you can still see the answers to those questions, and any that we don't get to, I will have the presenters answer in an email, and we'll send that out as well with the CLE numbers, any continuing education credit information, as well as a link to the next webinar. So go ahead and answer a few more questions while you got time.
So the next one, it was talking about if the LAR is insistent that they only want to seek SSLC. I mean, I think that's exactly what 944 was meant for, right? Was to bypass the LITA. So the LITA doesn't proceed with submitting the application. The LITA stays out of it. If the LITA doesn't think that the commitment is appropriate, but the LAR still wants the commitment, that's what 944 did. It allowed the LITA to say, well, we don't, so we're going to stay out of it, but parent, you can go ahead and do this yourself. And so the LITA shouldn't file or apply for the application. It should just let the parent file the application on their own, seeking that commitment.
Yeah, I don't disagree. I might characterize it a little differently. So I think of the IDT as being sort of a first threshold of examining those 4 eligibility criteria and making a recommendation on whether they believe that the person meets those 4. So, kind of normative judgments or appropriateness or not doesn't come into it so much as we're a team of experts who's familiar with what's available in the local milieu, and we're familiar with the person. We've examined the person's records. We understand what they are capable of, what their, strengths and needs are. And And we're going to apply that. We're going to bounce everything we know about the person and the resources off of those 4 criteria and then make a recommendation. So it does happen sometimes that they don't believe the person meets those 4 criteria. And often it comes down to least restrictive setting is the kind of linchpin. And so in that case, a number of things could happen. But the one that Beth mentioned, I think, is probably really apt, which is the person and the family will have heard about 944 already. They should not get to the point where they haven't heard that they can approach the court directly until after the IDT says no. And we made sure that that's included in the residential services options brochure and other things that parents receive up front. But it is possible that the IDT could say on our, in our best judgment, we don't believe the person meets criteria, but it's not for us to say. You can take this to the court directly, and SB 944 allows you to do that. They could also say, we'll submit our findings. It's not a recommendation for placement, but, so this work doesn't go to waste. We can submit this as a report to the court, and then the court will take it from there.
One of the questions was, can civil process be initiated if some kind of criminal process is still pending? So if the criminal process is, so really no, basically no. Unless charges are dismissed, the civil process cannot go forward. The criminal process is the one that takes, is the primary process that's involved. Now, ultimately, if the person is incompetent, which we'll talk about next month, the process ends up being the same civil commitment proceedings, but it's through the criminal court. So it is a separate process. But so no, unless charges are dismissed, the civil process cannot be initiated during that time.
All right,
we
well,
need-
yes, so any questions we did not get to, I will take and I will send to the speakers and we will get those questions answered for you. But I wanted to take a second to thank Beth and Erin so much for this wonderful presentation on an important topic. We will have our next webinar on August 20th. That topic is going to be forensic commitment of people with IDD to SSLC, so the forensic version of this, and there'll be further information in an upcoming email. So if you're registered for this webinar, I have your email and I'll send a follow-up in the next day or two, but there is in the chat the link to register for the next webinar, and I thank all of you so much for your participation, and we will see you next month.
Thank you.